ALS, Alternative Learning Systems.
Friends, in this video I am going to talk about NIA Amendment Act 2019. I hope you all know that we created a federal investigating agency to investigate terror cases of interstate nature with some international ramification in the year 2008, immediately after the Mumbai terror attack. And gradually this NIA has evolved in the country as a very powerful investigating agency at union level. Now the amendments which we have brought recently in 2019, experts are of the opinion that these amendments will establish the NIA truly as a federal investigating agency in lines of FBI in US, and it will also establish NIA more powerful than another investigating agency in the name of CBI. What you all need to know that NIA functions under the doctrine of concurrent jurisdiction. As per the federal polity of India, investigation is primarily the responsibility of state police. But we created NIA in 2008 with concurrent jurisdiction, meaning that NIA investigation can be ordered by this center on the request of a state, or if the center will order suo motu, then state will have the freedom and the liberty to continue with their own independent investigation. Now, what we have done in 2019 with the NIA Amendment Act, we have expanded the jurisdiction of NIA investigation. You know how? Earlier, NIA was empowered to investigate cases, terror cases, which were within the schedule of NIA Act. And the schedule of NIA Act included two important acts. Number one, Atomic Energy Act of 1962, and number two, Unlawful Activities Prevention Act of 1967. Now with 2019 amendment, in addition to terror cases related with Atomic Energy Act 1962 and UAPA Act 1967, NIA can now investigate terror cases related with human trafficking, related with offenses which are in connection to counterfeit currency or banknotes. It can also investigate cyber terrorism cases. It can also investigate offenses which are under Explosive Substance Act of 1908, and it can also investigate terror cases which are related with manufacture or sale of prohibited arms in India. So very significant expansion in the jurisdiction of NIA to investigate cases. But the most important expansion in the jurisdiction is in the form that now NIA can investigate scheduled offenses which are committed outside India subject to international treaties and domestic law of that particular country. This is for the first time we have created a legal provision in India where investigating agency of India will be empowered to investigate cases committed outside India, but of course subject to international treaties and domestic laws of other country. So 2019 amendment in NIA has expanded twofold expansion in the jurisdiction of NIA, which you learned just now. In addition to this, one important change which has been brought in NIA functioning through the Amendment Act of 2019 is that with the expansion in its jurisdiction, now more cases will be investigated by NIA. So NIA needs more special courts. So what change we have brought, that the central government can designate session court in a state as the special court for NIA with consultation with the Chief Justice of High Court concerned. Meaning any session court can be designated by central government as a special court for NIA, but while doing so, central government will have to mandatorily consult with the Chief Justice of the concerned High Court under whom the session court is functioning. So these are some of the changes which have been brought in NIA Act, and these changes have led to an debate in India. Most of the experts on constitution are of the opinion that the amendments in NIA undermines the role and the power of state within the federal polity of India as far as investigation of cases are concerned. You need to understand that one severe criticism is on this ground, that one of the important function of states within the federal polity of India is policing. And there are three facets of policing. One is prevention of crime, second is investigation of crime, and third is prosecution. So investigation should remain primarily the responsibility of state police. But what we are doing through NIA Amendment Act, that now cases of human trafficking, cases of arms, cases which are related with cyber terrorism, counterfeit currency, all such cases now can be investigated by NIA. These changes have been seen by many constitutional experts that it has adverse impact on federal polity of India, and NIA functioning in years to come will emerge as a bone of contention between center and state relationship. Another important food for thought, NIA has very high conviction rate. I would like to bring you some facts and figure for you to consider. Now the facts and the figure which you need to consider, this is not me saying, Honorable Minister of Home Affairs in Parliament has disclosed these figures. From the day of its formation till 31st July 2019, NIA is investigating 272 cases. And out of 272 cases being investigated by NIA, NIA has been successful in filing the charge sheet in 199 cases. And out of 199 in which charge sheet has been filed by NIA, in 51 cases, the special courts have already pronounced the judgments. And out of 51 cases in which judgments have been pronounced by a special court, in 46 cases, the accused have been convicted. So the conviction rate of NIA is 91%. Now, I fear that when we have expanded this much the scope and the scope of investigation by NIA and jurisdiction of NIA, if we will not correspondingly expand the organization and its structure, then there will be a lot of delay in investigation and there will be poor investigation with which the conviction rate will go down. And when conviction rate will go down, then it will have ill impact on deterrence as well. So definitely, the security threats which are there in India, and India being one of the worst victim of terrorism, we need to have zero tolerance policy towards terrorism. we need to ensure that we have a system of security apparatus in which terror cases are investigated properly and there is high rate of conviction. For that, we definitely need to give power to NIA. We need to widen the scope of NIA, but in this process, we cannot do something which may impact the federal polity of India and which in future can impact the image and the perception which this organization has built in the initial years with high rate of conviction. I would also like to bring to the notice of each one of you that with many changes which have happened in the recent past, the constitutional experts in India are saying that there is over-centralization of power in favor of center, and states within the federal polity of India truly are becoming glorified municipalities, which is not a very good sign for India, which is having a federal polity and a country with approximately 33 lakh square kilometers of area, a country with 1.35 billion population, a country with 2.72 trillion US dollar economy, a country with this much diversity. Over-centralization will not be good for governance, administration, growth, development, and a very different nature of society which we want to create in this country. So, definitely the changes which have been brought in NIA has led to triggering of this debate. So, I hope with this you can manage writing a good answer on any question which relates with NIA Amendment Act 2019. Thank you.